Several Democrats are sounding the alarm about the Supreme Court's leaked draft majority opinion, which indicates the justices may overturn Roe v. Wade. Now, some activists are worried that the court could roll back other protections, such as the right to same-sex marriage. CBS News legal contributor Jessica Levinson is here now to break this down for us. Jessica, good morning. It's good to see you.
Good to see you.
So, the draft opinion to overturn Roe v. Wade and the ruling to legalize same-sex marriage both rely on the 14th Amendment of the Constitution. Explain how that works.
Exactly right. So the Constitution, as we've talked about now for over a year, often on Supreme Court mornings, it's this brilliant document that leaves a lot of room for interpretation because the people who wrote it knew it was going to have to live not just for decades, but for centuries. So we have words like in the 14th Amendment, we're protecting our liberty. That's the due process clause. But what does liberty mean? That's part of what we've been interpreting for decades now. And first, what the court found is that under that word liberty, it protects our right to privacy. So next stop, what does right to privacy mean? We decided it means the right to obtain contraception, whether or not you're married or unmarried. We decided it means the right to marry the partner of your choosing. Maybe that person is of an opposite race or a different race. Maybe that person is of the same sex. We decided it means the right to obtain reproductive choice, that it includes the right to obtain a pre-viability abortion. And so that's what we're talking about when we're saying what's protected under the due process clause, what's protected under the right to privacy. It's this whole line of cases. What Justice Alito is arguing against in the draft opinion is, but it doesn't say those words. The only word I see in the Constitution is the word liberty. I don't see the right to privacy. I don't see the right to obtain an abortion. And that's why the decision in Dobbs, I think, would threaten that whole line of cases.
But in that draft opinion, as of course, I didn't read it, but I'm sure you did, it seemed as if he was trying to sort of answer that argument and kind of argue, well, abortion's different than these other things.
Absolutely. He says that specifically. He says, basically, don't worry. We're separating out abortion. There's something different about it. And of course, there is something different about obtaining an abortion versus marrying somebody of the same sex. But legally speaking, I think that just strains common sense because his complaint is this issue of so-called unenumerated, meaning not written down in the Constitution, rights. And he says it's not our job as justices to basically legislate what the Constitution means. And the entire draft opinion really goes after this idea of this is not my role. I'm leaving it up to the states because it's not written in the Constitution. If that's true, there's no way to distinguish, in my mind, the right to obtain an abortion, which we have said is protected under the right to privacy, versus the right to marry the partner of your choosing, which we similarly have said is protected under the 14th Amendment. Neither is specifically written in the Constitution.
Right, and so when I look at Section 1, which says no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. I mean, that seems to expand the civil and legal rights that all Americans enjoy as defined by what we mean by privileges and immunities. And so if it is the privilege of an individual to marry someone of the same sex because we agree that people should be able to they should be free to marry whom they choose, what would it take for a case that legalized same-sex marriage should be overturned?
So two things I would say. I'm smiling because my constitutional law students just took their final 2 nights ago, and we talked about the privileges and immunities clause as perhaps the place that would have been better situated to protect these rights. But the court basically read that clause out of existence. It really doesn't do much work. That's why we're talking about this word liberty in the due process clause instead. What would it take? I think not much at all. I think people are already set up to challenge the Obergefell decision. That was the decision saying marriage is a fundamental right, and we're not going to exclude anybody from obtaining that fundamental right, regardless of whether or not they want to marry somebody of the opposite sex or the same sex. So it's going to take somebody to challenge that right. It will work its way up the court. And then the big question will be, does the court take the case? Because there's nothing unsettled here. So if the court takes the case, it tells us where they're going, which is it tells us they want to change the law. It's exactly the same setup that happened with respect to abortion and the Dobbs case. They took the case. There was no reason for them to take the case.
How was the ideological makeup of the court different when the same-sex marriage opinion came down in June of 2015? Obviously, a number of these justices were on the court back then. I'm curious, the decision against it, I'm curious if you can recall what the argument was, the dissenting decision.
Yeah, so the court back when the Obergefell decision was made, which wasn't ancient history, we're talking about less than 10 years ago, it was a less conservative court. And you had Justice Anthony Kennedy, who made a series of decisions that were protective of gay rights. And he was the one who authored that 5-4 opinion. And he said, this is something that is fundamental to being a full person in this country. Now we have, of course, Justice Kennedy is no longer on the court. He was replaced by his former clerk, Justice Kavanaugh. And we have Justice Ruth Bader Ginsburg being replaced by Justice Barrett, a much more conservative clerk when it comes to these questions. You asked me, what was the dissenting argument there? Very similar to what we see, I think, Justice Alito's majority opinion espousing in the Dobbs leaked draft, which is, this isn't written in the Constitution. It's not our role to protect unwritten rights. And we're going too far. We're being activist judges. Justice Scalia, who was on the court when the Obergefell decision was made, famously said, also, this decision that Justice Kennedy made is applesauce, meaning he thought it was basically unmoored from any legal grounding.
Interesting. Jessica Levinson, thank you so much.
Thank you.